Welcome back to the final part of Law Sessions, Land Law, Registered and Unregistered Land Conveyancing. In the last segment, we were dealing with registered land. We continue in that vein, and just by way of very quick recap, I was saying to you that the best way to approach any land law questions is to ensure that you look at the interest and then you determine the three issues in relation to what the effect those interests have on a prospective purchaser. Section 27 says, if it is the type of interest which is subject to substantive registration, you need to ensure it is substantively registered. Otherwise, a purchase of a valuable consideration will take without such an interest and will not be responsible at all. Now then, I said to you before the break that Schedule 3 is that area which land law exams are pretty much made of. And it goes like this. Schedule 3 provides that interests which override a registered disposition will bind a purchaser even if he didn't know about them. Now there's a point to be made about Schedule 3, and it is this, that it is a principle which arguably has some degree of analogy to the doctrine of notice in unregistered land. So you will see, for example, in past years, you might get an exam question that says something like, can registered land be considered even by analogy to unregistered land? And what the examiner is speaking about there, of course, is Schedule 3. Because the idea behind Schedule 3 is these are interests which are not on the register, but it doesn't matter because it still binds a purchaser. Let's look at what these are. We've got Schedule 3, Paragraph 1, Paragraph 2, Paragraph 3. Under Schedule 3, Paragraph 1, it says that if you have a legal lease which is granted for 7 years or less, then that interest will bind a purchaser, even if he didn't know about it. So these are the types of interests which override what is called a registered disposition. And the registered disposition that is usually used, of course, in land law exams is a purchase. So the examiner will say, X is now selling Blackacre to Y, advise Y as to the effect A, B, C, and D rights has on him. And the first, of course, is if it is that any of the persons that the examiner gives you to discuss has a legal lease granted for 7 years or less, then that will bind a purchaser simply because it falls under Schedule 3. Now there are, remember I say that with the right itself, with the lease, we will speak, of course, in another lecture about what a lease is and how it is created. Schedule 3, Paragraph 2, very important one. In fact, it is so important that in the next 10 minutes or so, we will, of course, discuss it to some more depth. But that is, of course, the interest of a person in actual occupation. Again, this has caused some problems, but hopefully we will have clarified it before the end of this session. And the last one, of course, are legal easements that are not expressly granted or reserved. Now, if you have any of those interests, they will override a registered disposition and will bind a purchaser who has paid valuable consideration. So if you have, for example, a 2-year legal lease, then again go back to unregistered land. A 2-year legal lease, legal rights bind the world. In registered land, a 2-year legal lease, you're looking at a Schedule 3 situation. When we get to leases, we will flesh this out some more because one of the examiner's favorite is the 4-year lease. And that's where we will have to do some discussions when we get to leases. But there is a particular way where the right has to meet certain requirements. So a lease has to meet certain requirements. But then the question is, even if you're looking at a lease, so a legal lease, has it met the Schedule 3, Paragraph 1? If it has, then of course it will bind. Personal actual occupation will bind. Legal easement not expressly granted or reserved. We will of course explore this further when we look at easements. But the point here is that you can have a legal easement which has not been expressly granted or expressly reserved. And it goes like this. Let's assume for argument's sake that I am walking across Blackacre and I am the occupier of Whiteacre. But it is absolutely necessary for me to walk across Blackacre. And when I bought Whiteacre from the same person who owned Blackacre, a deed was used for the conveyance. Well, the point is that if it is absolutely necessary for me to walk across Blackacre to get to the main road, then of course the court will read back the easement into the deed, making it an implied legal easement of necessity. So it would be a legal easement, but it had not been expressly granted to me. It had come about by operation of law. As such, it would also amount to an interest which override a registered disposition and will bind a purchaser who pays valuable consideration, and as such, it automatically binds whether or not they are on the register or could have been put on the register. And that does raise some questions, because that second part appears somewhat unpalatable, because if it could have been put on the register, given that this is registered land, why not allow the person who has such a right put it on the register? But that's the way the statute is written. The last type of rights, of course, Section 34 and 43 of the LRA says that if you have an interest that doesn't fall under the Section 27 genre, for example, or it doesn't fall under the Schedule 3 type of interest, then you need to register it as a notice or restriction. Here, for example, you're looking at an equitable lease, for argument's sake. That doesn't fall under Section 27, because Section 27 is only concerned with leases which are legal and are over 7 years. Schedule 3 is concerned with leases under 7 years which are legal. So if you have an equitable lease, you have to avail yourself to Section 34 or 43. Equally, if you're looking at an equitable easement in registered land, of course, you would also be looking at Section 34 or 43 to ensure that your interest is protected. So a notice which is entered on the charges register or a restriction entered on the proprietorship register is an interest which has been entered as a notice, will be binding on a purchaser for valuable consideration, and a restriction regulates dealings with the land. All right, we will now finish off, of course, with actual occupation. And I think I've saved the best for last, because actual occupation is that interest which will, of course, fall under Schedule 3, Paragraph 2. Now, actual occupation has certain nuances, and if you can understand them, as I said, it will make your life a lot easier when you come to tackle the questions. Now, what is actual occupation? Now, this is a principle which has its origins in the previous LRA legislation, which is the LRA 1925 at Section 70, subsection 1, subsection G. And the idea is that if there is someone who has an equitable right and is in actual occupation, then any subsequent purchaser or third party takes subject to those rights. What is meant by actual occupation, though, is one of fact and degree, because there is no statutory definition. You have to look at it from the point of view of fact and degree. Now, occupation is a concept which may have a different connotation according to the nature and the purpose of the property which is being claimed. So, for example, if it is that I'm saying that I have a lease, then of course some degree of being present on the premises would certainly be required. But if I'm looking at, say, for example, occupation in the context of storing something, it may very well be the extent to which I have stored that thing. So, when you look at acts which are in preparation of taking up occupation, that will not suffice. But once you're in occupation, then that will give a right. So even if you are away from the premises on the basis of, say, a temporary absence, so you're on holiday, or you're in the hospital, or you're visiting relatives, this will not necessarily affect your occupation. Now, an interesting case which was decided under the old Section 71G is the case of Chucker and Chucker. And in that case, a husband and a wife contributed to the purchase price of the family home. The couple went to India in 1978, and the husband deserted the wife and he returned to the UK. Now, he sold the home and the cash proceeds were paid to him. He paid off his debts and he returned to India. Now, the wife, who was 7 months pregnant, returned home to the UK a few weeks later than her husband to find the locks had been changed, and when she entered the home, she was ejected by the new owner, a Mr. Palmer, who was still there. The court said that the wife was still in actual occupation and Mr. Palmer took the house subject to Mrs. Chucker's overriding interest and held that half of the interest in the trust was to be held for her benefit. Now, this is an example of a case where there was some fraudulent collusion and certainly action by the husband which harmed both the wife and, of course, the purchaser, Mr. Palmer. There was furniture there, they said. And they said this should have caused Mr. Palmer to have at least made some inquiries. And by not making his inquiries, of course, this penalized him and gave Mrs. Chucker an overriding interest. Now, this is a case where there was knowledge of the wife and the sale was apparently well below the market value. So, frankly, one has to consider if he was in fact a bona fide purchaser for value. Now, this is registered land, so it is not on the same principles of unregistered land. And the courts considered that when you consider the actions of the parties, then certainly an interest arose in her favor under a trust. Section 71G provided that an interest in land is an overriding interest where the person with the interest is in actual occupation, unless inquiries made of him or her and the interest is not disclosed. However, this section applies only where the person in actual occupation has an interest in land. This is extremely important. Simply being on the land is not sufficient. You must have an interest. So just because you are, for example, the spouse of the legal owner does not give you a right. But if you have an interest, for example, you contributed to the purchase price, but the property was transferred in the other co-owner's name or the legal owner's name, that is the other spouse, then the courts will say that your interest coupled with the actual occupation will, of course, be an overriding interest. This is important because sometimes people make the mistake of looking at actual occupation as a freestanding right. It's not. It's only in the US that you have community property and family assets. That does not operate in the UK. So this section does not convert something that is not an interest in land at all into something which is capable of binding third parties as an overriding interest. One of the things to consider as well is that someone may have, and you remember me raising earlier about the 4-year lease. That's a tricky one. Let's say you have a 4-year lease. Now, under law, a 4-year lease, to be a legal lease, must be by deed. But let's assume that it is in writing. So there's a contract, but it is not by deed. It gives you an equitable lease. Now, remember that an equitable lease needs to be registered as a notice or restriction, possibly. But let's say you didn't do that, but you have an equitable lease because you have the contract. Well, that equitable lease, coupled with the fact that you are in actual occupation, will also operate as an overriding interest. Examiners love to give this because a lot of times law students overlook the point. It is therefore important to establish what is the interest in the first place. Now, the new provisions in Schedule 3, Paragraph 2 has made some changes. It lists the interest that will override a registered disposition, and they include an interest belonging to a person in actual occupation so far as the interest relates to the land of which the person is in occupation. So there's, of course, the assumption that interruption of actual occupation will be more or less the same as it was before. However, there seems to be a slight shift of emphasis from the old law, because whereas Section 71G appeared, based on the Chocker case, appeared to be more friendly to the occupier, Paragraph 2 of Schedule 3 seems to be more friendly to the buyer. So, for example, it does not protect a person in actual occupation of whom inquiry was made before the disposition and who failed to disclose the right when he could reasonably have been expected to do so. Equally, it does not protect an interest which belongs to a person whose occupation would not have been obvious on a reasonably careful inspection of the land at the time of the disposition, and of which the person to whom the disposition is made does not have actual knowledge at that time. So going back to the Chocker case, would it have been decided differently? Well, you'd have to look at issues like, was there actual knowledge? Because if there was, then that would mean that the decision would simply be the same under the new improved Schedule 3. So if the person in actual occupation fails to disclose any adverse interest when questioned by the transferee before completion, then the interest will not be an overriding interest. But now, this is only so if he could reasonably have been expected to disclose it. So for example, say he doesn't know. It is the person with the interest who must be questioned and fail to disclose it, not the person giving. The significance of actual occupation is that a buyer must make himself aware of any occupational interest, and he must make inspection of the property and also make inquiries. The other significant thing, of course, is that there must be a proprietary right in the land which is protected by the occupation. So in Strand Securities and Caswell, Mr. Caswell had the long lease of a flat in London which was registrable but had not been registered or protected by any entry on the register. He moved to the country, but he allowed his stepdaughter and her children to live in the flat rent-free. Some of the furniture in the apartment was his, and he had used the flat occasionally for family meetings and as a place to change when he went out for the evening in London. The question before the court was whether his lease was binding on a purchaser of the reversion of the land. The court said it was not. They said the stepdaughter was in actual occupation, but only as his licensee. He was the one with the proprietary interest, the lease, but he was not in occupation, nor was he getting rent or profits. So I guess the moral of the story must be, if you're going to put your family in your property, maybe you ought to charge them rent or something like that. So in general, any proprietary interest can be overriding. There are a few statutory exceptions. For example, a spouse's matrimonial home rights under the Family Law Act 1996 cannot be an overriding interest, and so it must be protected by a notice. any interest which has been protected by entry on the register, of course, will no longer be overriding. And also a beneficial interest under a trust can be overreached even if the beneficiary is in actual occupation. Again, overreaching is where you pay the purchase monies to two trustees. It is one of the only principles which carry over from unregistered land as well. Overreaching applies in registered land. It applies in unregistered land. When we come to discuss mortgages, you will see that because of the definition of a mortgagee being the lender is a purchase of a value. And so you might get questions in an exam about whether a bank who advances money on a mortgage is bound by the occupational rights of a non-legal owner. The question is whether the non-legal owner's equitable interest is binding on the mortgagee as an overriding interest, with the result that he or she can take his or her share of the proceeds of sale in preference to the lender, or in worst case scenario, set up a right of occupation against the lender to prevent sale on a subsequent attempt by the lender to enforce its charge. Well, there are two cases, of course. There's Abbey National and Can, which considers the position. And what Abbey National and Can says is, if this is an acquisition mortgage, then unfortunately, you cannot set up your right over the mortgagee, as it were, because the idea is that the money was advanced in anticipation of purchasing the property. But what if, for example, you're looking at a remortgage situation? The case of Williams and Glynn's Bank and Boland is instructive in this regard. And in that case, if you're looking at a remortgage, then certainly the lender's rights will take precedence. I hope this has clarified the situation in relation to registered and unregistered land. And certainly, I would ask you to join us for the other lectures that follow from this.